This is Debt Free in 30, where every week we take 30 minutes and get practical advice from industry experts about personal finance and living debt-free. Here's your host, Doug Hoyes.
Today, we are going to talk about bankruptcy court. Why? 2 reasons. First, we've never talked about bankruptcy court here on Debt Free in 30. And second, a lot of people who are considering filing bankruptcy are worried that they will have to go to bankruptcy court, and that makes them nervous about seeking relief from their debts. So, let me alleviate those fears by starting with this fact. In the vast majority of cases, you don't need to go to bankruptcy court. If you go bankrupt and you complete all of your duties, and if no one objects, you are automatically discharged after the required period of time has elapsed. I'll oversimplify this a bit, but if this is your first bankruptcy and you complete all of your duties and no one objects, and if you have no surplus income, you are eligible to be automatically discharged in 9 months. If you're a first-time bankrupt with surplus income, you're eligible to be automatically discharged in 21 months, again assuming you complete all of your duties and no one objects. In a second bankruptcy, you can be automatically discharged in 24 months if you have no surplus income, or 36 months if you have surplus income, which is why many people choose to avoid a second bankruptcy by filing a consumer proposal, but you get the point. In most cases, you are automatically discharged, so no court appearance is required. It's only if you don't get an automatic discharge that you are required to appear in bankruptcy court to get your discharge from bankruptcy. So why would you not get an automatic discharge? And do you need a lawyer if you're going to bankruptcy court to get your discharge? Those are 2 questions I asked Richard Howell, an insolvency lawyer with Clark Farb Fiscal in Toronto. I started by asking him to give me some common reasons why your discharge would be opposed. Here's his answer.
Well, first of all, if you're going to court, it's because you didn't do something you're supposed to, or you did do something you're not supposed to. Typically, you may not have paid surplus income, you may not have done your counselling, you may not have provided tax information to the trustee. Those are the basics. There are more exotic ones, for want of a better word. You may have transferred the house to your spouse 6 months before bankruptcy. That'll be attacked. You may have had you may have objections from creditors for any number of reasons. A lot of them aren't valid. So unless it's a fairly simple matter, you better at least talk to a lawyer. And if it's one of the more serious matters, you better hire one.
So let's talk about that then. When do I need a lawyer going to bankruptcy court? So you've given some examples, and I guess there's really 2 reasons why you're in bankruptcy court. One is, like you said, you didn't do something you were supposed to do. You also alluded to the fact that, well, it's possible that one of your creditors is objecting, and it may not even be something valid. They just might be, having a bad day and mad at you. So even though you've done everything you're supposed to, you still find yourself in court. Under what circumstances is a lawyer not really that necessary? And under what circumstances, as you say, should you at the very least have a phone conversation with one before appearing in court?
Well, typically on the surplus income issues and on the lack of counseling, you can fix that beforehand with a trustee. That will get the opposition withdrawn, although you'll still have to go to court if you didn't get your auto discharge.
Right. And so a typical example, credit counseling being the obvious one, there are certain time periods that it has to be done in. If you haven't done it in the time frame, and certainly if you haven't done it by the time your automatic discharge period comes up, you're not eligible for an automatic discharge. The trustee has to make an application to court for your discharge. If you can get it fixed, in other words, do your counseling before court, then it's a relatively simple matter. We go to court, you say to the judge, yeah, I'm sorry I was late, but it's done now. And the trustee says, yep, we're cool. They sign off and we're done. So no need for a lawyer there. Surplus income being the other one where, okay, I was supposed to pay a certain amount of money. I wasn't able to get it paid within the time frame, but now it is paid. So again, you go to court and get it done. Those are examples where a lawyer, not really necessary. What would be some examples, though, where, yeah, you know what, you might want to get some help?
Well, the classic one is transferring an asset at a time when you were insolvent. If if you're a second or third time bankrupt, or if you're a tax-driven bankrupt under the Bankruptcy Act, then you better have a lawyer because a lot of things can happen. Another example that happens fairly often is you may have a creditor that alleges you've committed fraud. That's not something the bankruptcy court will try on a discharge, so that's not going to be decided at the discharge hearing, but you better have somebody around to protect you.
So something outside the box perhaps is a good idea. And, a tax-driven bankruptcy, and we won't go into the specifics, I'll put some links in the show notes, but if your total tax debt is over a certain amount and it represents a significant portion of your total debt, then that's a tax-driven bankruptcy. You're not eligible for an automatic discharge. The court has to sign off on it. And in that case, as the trustee, if I'm in court, I'm going to say to the judge, well, here's the facts. This is what the numbers are. That's why we're here. It's not really my position to tell the court, well, here's what I think you should do, because in a lot of those cases, Revenue Canada is going to be there as well. Is that accurate?
If you're tax-driven and they've opposed, they'll be sending the Department of Justice lawyers to argue what you should have to pay to get out of bankruptcy.
And it will be a high number probably if they're going to be showing up.
Yeah, there's a tendency, the low number tends to be 10% of the debt. The high number, I've had bankrupts ordered to pay $500,000 as a condition of getting out of bankruptcy.
That's Richard Howell, an insolvency lawyer, talking about tax-driven bankruptcies. As I said, I'll put links in the show notes at hoyes.com, but the section we are referring to is subsection 172.1 sub 1 of the Bankruptcy and Insolvency Act, and that section says that a bankrupt is not eligible for an automatic discharge and must have a discharge hearing in bankruptcy court if, at the time they filed for bankruptcy, they owed $200,000 or more in personal income tax debt, and that personal income tax debt represents 75% or more of their total unsecured debt. Again, we're talking about special circumstances here. If you owe less than $200,000 to CRA, you do not automatically have to go to court. And, as Richard Howell says, CRA's lawyers from the Department of Justice will likely also be in court if they are opposing your discharge because it's a tax-driven bankruptcy, and they will likely request that the court order you to make additional payments to get your discharge, which is why having your own lawyer to give your side of the story to the court may be a good idea. So to summarize, in the vast majority of cases, if you go bankrupt, you are not required to go to bankruptcy court. You get an automatic discharge and you're done. However, if you don't complete your duties, or if you are a tax-driven bankruptcy, or if a creditor objects, you are required to go to court. So let's say that, for whatever reason, you are required to attend a discharge hearing in bankruptcy court. What should you expect? How do you prepare? I asked Richard Howell a basic question. What should you wear? Here's his answer.
Be who you are. If you're used to wearing a suit to church or something, wear it. If you're a laborer and don't have a suit, or just be who you are. The court doesn't take a lot of note of how you're dressed, but it's always a good idea to put your best foot forward.
Okay, wear a clean shirt kind of a thing, but don't try to be someone who you're not.
Well, as Johnny Cash says, at least get out your cleanest dirty shirt.
There you go. Well, it kind of makes sense. If I'm a laborer, why am I showing up in a fancy suit? That seems kind of out of character. If I'm an accountant or a lawyer, well, okay, it's not so unusual, I guess. So
yeah, the gold chains are not a good thing to wear to court.
Yeah, a lot of jewelry probably doesn't go over well. And other than that, show up on time, I guess. Is that really what it comes down to?
Yeah, you show up on time. You won't get reached on time because there's going to be 20 or 25 other bankrupts on the docket. And it depends. The court can go through them awfully quickly if they're consent matters. If you get one that takes 15 or 20 minutes, it sort of stalls the proceedings.
And in Toronto, the morning session typically starts, is it 10 o'clock in the morning?
10 o'clock, yeah.
And is there an afternoon session typically as well?
No, they go through, they haven't split them. There was a consideration of doing that, but no, generally speaking, the court will finish by 12:30 or 1 98% of the time.
So if you have a court time of 10 o'clock, everyone has a court time of 10 o'clock. And as you say, if there's 20 or 30 people on the docket, well, your time might come up at 10 o'clock. It might be 11, it might be 12, could even be 1 o'clock, I guess. So be there early and wait your turn.
Yeah, quite so.
Is how it works. Okay. And is there anything you should do or shouldn't do in court? So, for example, and I'm speaking specifically about Toronto court here, but I think this would apply to bankruptcy courts across the country. How am I supposed to address the judge? What am I supposed to say?
Well, I've heard, first of all, the judge isn't a judge. The judge is technically a registrar in bankruptcy that is kind of like a judge, but it has restricted powers as to what they can do. But the registrars in Toronto are masters of the Superior Court as well, and they like to be referred to as master. Now, over my many years, I've heard judicial officials referred to as Your Highness, Your Lordship, Your Worship, right down the scale.
You don't recommend that, though?
No. It used to be fun calling them their lordship, but for the judges, but that doesn't happen anymore. And if you forget, sir or ma'am.
Pretty simple. And we're recording this in the spring of 2018, and obviously it's a podcast, so people may be listening to this at some point in the future. At the moment, the two registrars in the Toronto court are both female, so obviously you'd be referring to them as either master or ma'am, I guess. I guess the simplest advice would be, if you are there with a lawyer or if your trustee is there, ask them. You know, what am I supposed to do? What's the plan here?
Well, exactly, and you're going to get to see a few of these before your case as a general rule, so you can probably get a little more comfortable realizing that the court's understanding, and they're not going to give you a rough time if you don't deserve a rough time.
Yeah. And is it typical that they go through the docket in chronological order, or is that not typical?
Well, first of all, they take the adjournments. Then typically they'll take the first trustee on the list, may have about 10 matters scattered. So they'll take the first trustee on the list and do their 10 matters, unless they're going to be a long time, in which case they take other matters in front. So they have a certain discretion as to how they do things. Consent matters tend to get heard earlier as well.
Gotcha. And in the times I've been in court, if there are going to be 5 or 6 different trustees there and we've each got a few matters, it's not unusual for us to sort of chat beforehand and say, well, what do you have? What do you have? And if I say, well, I got 3 people and they're all creditor oppositions, I guess I'll go at the end. Let's get the courtroom cleared out as much as possible, because most matters are pretty quick, but some can take a lot longer. So like you say, if we're just adjourning it, or we've both agreed on what it is, it's just having the judge sign off, then it'll go. So you want to be there on time, and you want to just keep your eyes open and your ears open for when your name gets called, and be ready to go.
Yeah, and speak to your trustee beforehand, or whoever the rep from your trustee is. Make contact. Let them know you're there.
That's good advice. Speak to your trustee beforehand. How does that work? To find out, I've asked Scott Schaefer to join me back here in Kitchener in the Debt Free in 30 studio. Scott is a licensed insolvency trustee, and over the last decade and a half or so, Scott has appeared in bankruptcy court as the trustee on hundreds of files. So, Scott, how does it work? What's the process? Rick Howell says to talk to your trustee before court starts. How do you do it here at Hoyes Michalos?
Well, we talk to people. The bankruptcy is a process, and if we're going to court, we're going for a discharge hearing. So we're going to get their discharge is what the ultimate goal is. So with that in mind, as we work through the process, if we are ending up having to go to court, we want to meet with a person, we want to work with a person, we want to be prepared for the court hearing, because it doesn't happen in all the cases. It happens rarely.
So how far in advance do we know when a court hearing is going to happen?
Several months.
Several months, okay.
At least 3, if not more months ahead.
Okay. So I know that 3 months from now, 4 months from now, there's going to be a court discharge hearing. When are you going to meet with the person involved?
We would have probably met with a person several times. We're definitely going to meet right before the court hearing just to double check things. We're going to meet when we know we have to go to court to get their discharge, and we'll have talked about it before that ever gets to that point. So we'll know well in advance as we move through the process on that.
And obviously the goal is to get everything done so that by the time we get to court, there's really nothing to do. So if the issue was I owed a bunch of money, I had surplus income and haven't paid it or whatever, and I'm not going to overcomplicate this by talking about mediation and all the other ways that we deal with that. But let's just say that we've got a situation where the person owes $1,000, hasn't been able to pay it before the end of their automatic discharge period. It's, 5 months before court's going to happen. You meet with the guy and he says, hey, look, I can give you a couple $100 a month.
Correct. We're using the court hearing at that point as a tool to help that individual get their discharge. They couldn't afford to pay it in full. So the tool now is the courts can allow us and agree to a term to get their discharge conditionally upon that condition being met, which is the payments. So it allows us to spread out those payments a bit longer than we would otherwise have been able to.
So if everything gets done before court happens, then it's pretty easy. You go to court and say to the judge, everything's done.
Correct. We go and we ask for an absolute order of discharge.
Absolute order. Okay. Yeah. And which means everything done. Now, you had mentioned a conditional order. So that would be a case where everything isn't done, but we're getting close. So maybe we go to court and there's still, a couple $1,000s still to pay, and the guy can afford to pay a couple $100 a month. So you would say to the court, can you give him a discharge conditional on him paying $200 a month for 10 months?
Correct. I would have already met with the individual. We probably would have worked out payment terms to say, you know what, let's pay $200 a month for the next 5 months. We'll sign a consent to condition, meaning we're both agreeing to those terms. I will present those to the courts to say, we've already come to terms with the payment plan. We would like a conditional order be granted upon those terms.
So you agree with the bankrupt on whatever the terms are, $200 for 5 months, $200 for 10 months, whatever he can do. He agrees. And so then when you're going to court, really you're getting the court to already rubber stamp what we've all agreed to. It's pretty simple at that point.
They're just giving us more time to make those payments. So it's a helpful tool.
Helpful tool again. Okay, so that's what happens before court. Let's assume now today is court day.
Okay.
So you do most of your work in the Kitchener court. I know you've been in both London and Toronto before. In Toronto court, discharge hearings are typically at 10 o'clock in the morning. How does it work in Kitchener?
Yep. So if it's a trustee's request for the court hearing because we needed more time or there was outstanding duties, it's at 1 o'clock. If it's a creditor opposition, meaning the creditors would like a review of it, then it's at 10 in the morning.
So it'll either be at 10 o'clock or 1 o'clock. And so let's say it's 1 o'clock, which is when the typical ones would be. When should someone arrive at court?
I always like to tell people be an hour beforehand. You never know what the traffic's going to be like. Most courts are in a downtown community, so there's going to be a parking issue. You got to go through security because there's all the courthouses now have ample security, so you're going to have to go through the security system. You're going to have to find the courthouse, so you're going to have to ask the front desk what court you're in. So you just want to have some time so you don't feel rushed. You don't want to feel pressure going into it.
And we don't know in advance what room you're going to be in the courthouse. We know where the courthouse is. It doesn't move around. But because the registrar or deputy registrar is only there once every couple of months in Kitchener at least,
correct,
they could be in a different courtroom each time.
Yeah, they schedule it based upon what else is going on in the court. So it does float around to different rooms.
And what's security like at the court?
It's like going through airport security. You go through, you got to empty out your pockets. You got to go through a X-ray or the scanning machines, and they just like going through out of the airport.
And has nothing to do with bankruptcy court. This is a court that also has, murder trials and everything else. So as a result, there's heightened security. So even though your matter isn't particularly contentious, you're in a court building. So get there early. Gets you time to find a place to park, get through.
And one of the biggest things is then they can locate us because at Hoyes Michalos, we attend all court hearings. So they can find us beforehand. We'll set them at ease again where we're going, what's going to happen, at what point they'll be called up, and just get them a little bit we'll go through it one more time of what's going to happen so that there's definitely reducing the stress for the person.
So I find the court, I get there, I go through security, I find out what room it's in, I look at the board or I ask someone, I go up to room whatever, and there's going to be a whole bunch of people milling around around, because at the 1 o'clock session, there could be how many people on the docket?
It could be 50 or 60 people.
So there's a lot of different people who are getting their discharge that day. So a lot of people mulling around. So they know that Scott Schaefer is my trustee. I go, I find him, and you say, no problem. I'll tick my book here to make sure I know you're here.
Yep.
And then when court starts, what happens?
Yep, we all go into the courthouse. At that point, you want to make sure you're not wearing a hat and your cell phone's off, as the courts frown upon that. But at that point, you have a seat and you wait for your name to be called. The trustee will have already checked in to say we're present, and then the trustees will be called up in different orders to deal with their matters in block chunks. Yeah,
and so typically, as Rick Howell said, there may be some consent matters that can be dealt with really quickly. Otherwise, I guess if Hoyes Michalos has 20 different people on the docket, that would be unusual. But if we had a lot of people, then it may be, well, we're going first or second, and we'd go through all of our people at once.
Correct.
And so you'd just be up there saying, okay, Your Honor, we'd like to do the next person next. You'd wave to them. They'd come up, say their piece, and go on to the next one.
And if we're on consent, the judge will just ask at that point, or the registrar or master will ask, do we agree with that? In general, there's not a lot of questions asked. If it's multiple time bankruptcy, there'll be some questions asked. But generally, it's a very straightforward process.
And you said that the Hoyes Michalos process is to always appear in court for a discharge hearing.
Correct.
Have you ever been to court where other trustees aren't there?
Oh, multiple times. There's several different trustee firms that do not attend these court hearings to facilitate it.
And so that's got to be pretty confusing for the bankrupt then.
Confusing, stressful, anxious, you name it. I'm sure it's all there.
Because they've never been to court before, and okay, where am I supposed to stand, and what am I supposed to do, and when's my turn come up?
And we are in a court, and I still go back to people, remember that this is about a discharge hearing. So it's a hearing to get somebody's discharge. The discharge will happen at some point. It's just a matter of having to use a court to do that. So yes, we use the word court, and we've seen lots of TV shows where courts are involved, and it could be scary, but at the end of the day, this is about getting somebody's discharge.
And that's what it's all about. So what advice do you have then for people who have a court discharge hearing scheduled? What do you tell them? Is it as simple as that this is about resolving, your duties and getting on with it?
Bankruptcy is about giving the honest but unfortunate debtor a fresh start, helping them through the process, and a fair and equal treatment of all the creditors. So at the end of the day, the courts want to grant discharges. That is what the process is about. Sometimes there's terms and conditions they have to meet in order to facilitate those three principles. But at the end of the day, this is about getting their discharge. So we got to make sure we agree on getting the duties completed and moving forward to getting that discharge, which is where it's all about that fresh start.
Excellent. Well, I think that's great advice. The court wants to give you your discharge. They're not trying to trip you up or anything. They would like this to be done just as much as you do.
Yeah, the court has 4 options. They can absolutely discharge you. They can give you a conditional order of discharge, which means there's a condition that has to be met. They can suspend your discharge, which is where somebody's been a multiple time bankruptcy. Sometimes they add a period of time before they're able to get their discharge. So it's a time penalty. And there's also the option to refuse a discharge, which in my lifetime, I've never seen a refusal. And that would be for maybe a 5th time bankruptcy or something very unusual where there would have been criminal activities involved or otherwise.
But otherwise, it should go according to plan. Excellent. Scott, thanks very much for being here.
Thanks for having me.
That's some great advice. So here's the quick summary. In most bankruptcy cases, an appearance in court is not required. If you complete your duties on time, you are automatically discharged. But if you don't complete your duties on time, or if someone objects, a discharge hearing in bankruptcy court is required. And my number one piece of advice, and I think Scott would agree, is to meet with your trustee before you go to court. That's standard practice here at Hoyes Michalos. You should know what to expect before getting to court, and ideally you and your trustee will have worked out a game plan to deal with any issues that may arise. That's our show for today. A full transcript of today's show and links to Section 172 of the Bankruptcy and Insolvency Act, which talks about tax-driven bankruptcies, and a link to an article on creditor oppositions can be found at hoyes.com. That's HOYES.com. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.